I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the second part in a four-part lawcast on the direct public offering process, commonly known as a DPO, including the filing of a Form S-1 registration statement. In the last part of the series, I identified and gave a brief summary of four governing regulations involved in the preparation and filing of the S-1 itself. Today, I'm going to give a brief summary of how the different parts of the S-1 must be written and the filing process itself. In particular, all registration statements must be written in plain English as opposed to legalese or industry terminology. The plain English rule requires that the registration statement be written using active voice, short sentences, definitive, concrete, everyday words, and using tabular presentations of financial information and other applicable data, using bullet lists for complex and material data whenever possible, and avoiding legal jargon and avoiding highly technical business terms and multiple negatives. Once the Form S-1 is filed with the SEC via the EDGAR system, the SEC will appoint a reviewer and let the issuer know who that reviewer is. All S-1s for first-time initial offerings are fully reviewed. The SEC will provide comments to the issuer, who then responds to the comments and amends the S-1 accordingly. The comment and amendment process continues until the SEC has no further comments, which is commonly referred to as clearing comments. The issuer can then request that the SEC accelerate effectiveness of the S-1 and declare it effective. A request for effectiveness is coordinated with the SEC reviewer. There are times when the SEC will not entertain a request for effectiveness, but rather will require that the company allow the S-1 to go effective by operation of law. Legally, a request for acceleration of effectiveness includes a finding by the SEC that effectiveness is in the public interest. Although the refusal to accelerate effectiveness has previously been a very rare occurrence, the SEC has now taken the position that it will not accelerate the effectiveness of cannabis-related industries that are or may be in violation of the Federal Controlled Substances Act. In that case, the company, once it has cleared comments, must file a final clean S-1 and let it go effective by operation of law after 20 days. Once the S-1 goes effective, the issuing company can proceed with the sale process. A sale is completed much the same way as in a private offering. That is, an investor executes a subscription agreement and pays for the securities, which are then issued to the investor by the transfer agent. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about any of the information we've just covered, visit securitieslawblog.com or contact me directly. Inquiries of a technical nature are always encouraged.